Welcome to the student seminar of the Presidential Lecture Series and the Philosophy Forum. It gives me great pleasure this afternoon to welcome Professor Carlin. She is the Kenneth and Harley Montgomery Professor of Public Interest Law and the co-director of the Supreme Court Litigation Clinic at Stanford. And I have it on the authority of my daughter Caitlin, who is also a law professor, that Professor Carlin is the leading constitutional scholar of her generation, but also an activist who, as co-director of that clinic, has provided help before the Supreme Court impartially and successfully. And you will get a full account of her accomplishments this evening when at 8 o'clock in the University Center she will talk about keeping faith with the Constitution, which is also the title of her most recent book. Most important for this afternoon, Professor Carlin has been a champion of gay rights. And at a time when a little sunlight has fallen upon gay rights in Washington, D.C., and dark clouds are hovering over the rights of gay and transgender people in Helena, there couldn't be a better time to welcome Professor Carlin. And we will talk this afternoon about the gay and the angry, the Supreme Court, and the battle surrounding same-sex marriage. Please join me in welcoming Professor Carlin.
Well, thanks so much for that introduction. And it does turn out to be a kind of timely topic, even more so than when I started working on the paper that my talk today is based on. And you know, marriage is popping up in the oddest places these days at the Supreme Court. And I start off my paper with a quotation from an opinion by Justice David Souter right before he left the Supreme Court. And the opinion was in a case that on its face doesn't seem to have anything to do with same-sex marriage at all. It was a case about whether individuals who've been convicted of a crime can request testing of the DNA evidence that's still in the state's possession so that they can show that they actually didn't commit the crime. So they've gone through the whole trial process and they were convicted at a trial, but now it turns out with new DNA testing possibilities, they want to say, let me test the evidence again because I really think it'll show I didn't do it. And so in deciding this case, this is what Justice Souter wrote. It is essential to recognize how much time society needs in order to work through a given issue before it makes sense to ask whether a law or practice on the subject is beyond the pale of reasonable choice and subject to being struck down as violating due process. And let me pause here for just a moment and ask, how many of the people in this room have gotten past the first year of law school? Okay, so I'll try to make everything very accessible for all of you. It's not actually rocket science. That's why we can do it in 3 years and we don't need a PhD for it. But the Due Process Clause in this sense is the source of fundamental constitutional liberty interests. That is, the Due Process Clause is treated as the clause in the Constitution where we look to ask whether something is a fundamental liberty. And so Justice Souter is writing about whether, in this case, Alaska's refusal to allow retesting of DNA violates the fundamental liberty of people who've been convicted of a crime. And here's what he says. He says, changes in societal understanding of the fundamental reasonableness of government actions work out in much the same way that individuals reconsider issues of fundamental belief. We can change our own inherited views just so fast, and a person is not labeled a stick in the mud for refusing to endorse a new moral claim without having some time to work through it intellectually and emotionally. Just as attachment to the familiar and the limits of experience affect the capacity of an individual to see the potential legitimacy of a moral position, the broader society needs the chance to take part in the dialectic of public and political back and forth about a new liberty claim before it makes sense to declare unsympathetic state or national laws arbitrary to the point of being unconstitutional. So when I read this passage, I thought to myself, this man cannot possibly be talking about whether or not you have the right to engage in DNA testing of evidence. I mean, what individual even has an inherited view on that question? I mean, our ancestors didn't know from DNA testing. So the idea that you would have an inherited view on this question makes no sense, let alone the idea that that inherited view, if you had learned about DNA from your dad or something, involves issues of fundamental belief. And post-conviction DNA testing hardly seems the kind of question that society needs to work through, one of those wonderful kind of psychobabble phrases, right? Work through in some therapeutic or dialectic way. It's an important question, there's no question about that, but it's a pretty narrow question of law. But if you think that what Justice Souter was writing about was not DNA testing, but he was actually leaving some hints behind, and if any of you here are political philosophers, we might think of this as kind of Straussian reading of what Justice Souter is doing. Well, the right to same-sex marriage, that fits the bill entirely, right? That's about inherited views, deeply held moral positions, and the like. So that makes a lot more sense. What's going on there, of course, is a change in social attitudes that really, I think, has a velocity behind it of almost no other change I can think of. And just a sort of autobiographical moment here, I clerked at the U.S. Supreme Court the year that the court decided a case called Bowers against Hardwick in 1986. And this was a case in which the Supreme Court held 5-4 that Georgia could make adult consensual sodomy a felony, a 20-year felony, in fact. And Justice White's opinion for the court there said it would be facetious to suggest that gay and lesbian people have a right to engage in sexual intimacy. There's nothing in the Constitution like that. And Chief Justice Burger wrote a separate opinion that quoted back to some 17th and 18th century scholars who had said sodomy was a worse crime than murder. Maybe not for the victim, but in any event, and I was at the courtroom when the case was argued, and the justices' hypotheticals at the time of the argument, the justices' hypotheticals were things like, well, if we allow this couple to engage in sex in their apartment, isn't the next thing that's going to happen? People are going to be having sex in cars and in bus stations and things like that. So fast forward from that was 1985 when the argument took place, and 1986 when the opinion came down. Fast forward to that, the Supreme Court's decision in 2003 in the Lawrence against Texas case, where the court held 6-3 that the liberty embodied in the Due Process Clause is broad enough to allow same-sex couples to engage in consensual private sexual activity. This time around, when you went into the courtroom, almost every LGBT clerk in the history of the Supreme Court was there to watch the argument. The man who argued the case was an openly gay former Supreme Court clerk for Justice Lewis Powell, who had announced at the time of Bowers against Hardwick that he didn't think he had ever met a homosexual. When the justices came out, you could kind of see them. They came out and they looked around the courtroom, and you could see them going, yeah, it's like duck, 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 goose. And the argument was, the tone of the arguments was completely different. Well, what happened in that time period was just a huge social transformation. From justices who thought they had never met a gay person to justices who not only knew that they'd met gay people, but knew and liked those people. And that had a powerful effect on how they thought about the law. In the same way that we've moved since 1996 from Congress passing the Defense of Marriage Act and Bill Clinton signing it into law to Attorney General Holder announcing yesterday that he didn't think the federal government could effectively defend the Defense of Marriage Act because he thinks homosexuality is what's come to be known as a suspect classification, the kind of line that when the government draws it, it's presumptively unconstitutional, and the government has to come in with a really good reason for it, unlike lines that are based on test scores or age or income or the like, which the government is virtually free to draw. So we have moved incredibly fast in the United States from a situation in which homosexual sex could be criminalized to a situation in which 2 in 5 Americans now live in states that either provide marriage rights or provide other legal recognition for same-sex couples. And as I say, the velocity of that change is incredibly fast. Now that change is going to raise a question which everybody assumes the Supreme Court's going to decide soon, and whether it decides it soon or not, they're certainly going to decide it in the foreseeable future, and that's whether the Constitution requires states to provide legal recognition for same-sex couples. We're not going to achieve national uniformity on this anytime soon unless the Supreme Court acts, in part because as a reaction to Lawrence against Texas, a number of states amended their state constitutions to provide that marriage consists of only one man and only one woman. And it will take a long time before that will change, particularly in some of the states of the Confederacy. I thought of bringing a whole bunch of slides with me today, but I often find that kind of distracting, particularly in what's supposed to be a seminar. But if you look at the states that provide no legal recognition of any kind for same-sex couples, they look almost exactly like the states that were still denying interracial couples the right to get married as late as 1966. And that required the Supreme Court to step in a case called Loving against Virginia and recognize a right to interracial marriage, even though there were still 16 states then that made it a crime. But here's one of the big differences, I think, between the Loving case. And that's a wonderful name for a case that's about the right to get married. You know, where do they find people with names like this? You know, Robert and Mildred Loving. But by the time the Supreme Court decided Loving, it had already taken sides in what might have been thought of as the culture wars of racial justice. It had decided it was standing with African Americans on every single issue. And the last thing they reached in the progression was the protection of interracial marriage rights. So that by the time the Supreme Court decided Loving, it had already decided that the Constitution, in Chief Justice Burger's words, places no value on discrimination. And even if we have to allow people to engage in some discrimination in their private lives, he said, it has never been afforded affirmative constitutional protection. Now, when it comes to gay rights, the Supreme Court's path over the last 20 years has been somewhat more equivocal. On the one hand, there have been a series of cases where the Supreme Court has ruled in favor of LGBT people. In Romer against Evans, a case of some relevance to what's going on right now here in Montana, the Supreme Court held that the state of Colorado couldn't essentially override the anti-discrimination provisions that protected gay people in Boulder and Denver, and there also a governor's executive order. And in Lawrence against Texas, as I already said, the Supreme Court struck down sodomy statutes. On the other hand, there were other cases, and the two most notable ones are a case called Hurley against Irish American Gay, Lesbian, and Bisexual Group of Boston, and a case called Boy Scouts against Dale. And these were cases. Hurley was about whether the people who ran the St. Patrick's Day parade in Boston had to allow a gay group of Irish, you know, kiss me, I'm gay and I'm Irish, to march in their parade as well. And the Boy Scouts against Dale case involved the question whether New Jersey could force the Boy Scouts to allow a gay man to be a scoutmaster when the Boy Scouts took the position that you couldn't be associated with the Boy Scouts if you were gay. In those two cases, the Supreme Court protected the right of these organizations to exclude gay people on the grounds that the First Amendment, which protects freedom of association, protected the right to make these associational decisions even on the basis of sexual orientation. And Chief Justice Rehnquist's opinion for the Supreme Court in the Boy Scouts case drew a direct link between the fact that society was changing and the need to protect the Boy Scouts and their decision to exclude gay scoutmasters. And he wrote that it appears that homosexuality has gained greater societal acceptance, but that is scarcely an argument for denying First Amendment protection to those who refuse to accept these views. The First Amendment protects expression, be it of the popular variety or not. And the fact that an idea may be embraced and advocated by increasing numbers of people is all the more reason, it's all the more reason to protect the First Amendment rights of those who wish to voice a different view. Now, to my mind, the marriage question looks much more like Romer and Lawrence than it looks like Hurley or Dale, because gay people are seeking access to a state-created institution, here civil marriage, rather than a privately run activity. And there's no question that even if a state recognizes same-sex marriage, any individual private marriage officiant, a rabbi or a priest or, one of those ministers for a day to marry their family, any of those people can refuse to marry anyone for any reason or no reason at all. But the civil institution of marriage, the thing that you get the license from the state for, is a state-created status with a whole bundle of benefits attached to it. And that's what gay people are seeking access to. So whatever the merits of the kind of metaphysical debate over what marriage equality is about, and there's this very metaphysical debate out there about whether allowing gay couples to get married somehow dilutes or taints the marriage of same-sex couples, as if marriage is a sort of scarce resource. We only have a certain number of licenses to go around, and if we start giving them to gay couples, there won't be enough left for all the straight people who need them. Or, just knowing that couples whose views I disapprove of and whose behavior I disapprove of are doing the same thing I'm doing, it injures me somehow, right? It's a sort of real problem if you think about the million harm principle as what justifies the government's behavior. Well, it's really hard to see that those couples could bring a legal challenge in any event. So, for example, in Connecticut, which now recognizes same-sex marriage, opposite-sex couples don't have some legal claim that their rights have been violated by the state here. But that being said, the purpose of my paper in some ways is to explore the fact that the constitutional law issues that are going to arise out of this movement towards marriage equality and the like don't just involve the claims of gay couples who want to get married. They also involve the claims of what a friend of mine, when I showed him the paper, kept wanting me to call the cultural rear guard. That is, traditionalists who oppose same-sex marriage, and how to accommodate their claims and what respect their claims demand is an issue that's going to confront the Supreme Court every bit as much as the claims of LGBT people for equality. Now, last term, the Supreme Court got a taste of what's going to come, and they had 3 cases there last term, and I'll summarize the cases very briefly for you. And then I thought in my prepared remarks what I would do is focus on one of the cases that actually has some interesting salience to the university here, because it involves the same group that has been threatening, or perhaps has actually sued you, as opposed to just threatening to sue you, which is the Christian Legal Society. So let me just say a little bit about the 3 cases first. The first of these is a case called Hollingsworth against Perry, and it was about whether the judge who was hearing the California marriage case should have the right to put the trial on TV so everybody could watch it from closed circuit in other courthouses. State courts allow all sorts of televising of trials. In some states, anybody can come in and televise a trial pretty much. But federal courts have been very leery about this. Federal courts are sort of the last bastion of we don't really understand very much about technology. Justice Souter, before he left the Supreme Court, was famous for going up in front of Congress, and when he was asked, how about televising the Supreme Court hearing, said, they'll have to roll the cameras into the courtroom over my cold, dead body. And he's not a man of many words, so that was a lot of tough words from a guy who usually doesn't say very much. So Hollingsworth, the Supreme Court held that the trial could not be televised. Now, the actual way they did it was a very narrow legal technicality that, having polled the audience on what your legal background is, would be so uninteresting to you, I'm not going to spend any time on it. It involved questions about administrative procedures and the timing of notice and comment rulemaking. I noticed people are starting to slump down in their chairs even thinking about it. But behind that was the Supreme Court's sense that this was a very bad case to televise, and they talked about this at some length. This was a very bad case to televise because it might lead to harassment of the people who are trying to defend Proposition 8, which is the proposition that limits marriage in California to opposite-sex couples. That these people might be harassed in various ways if the trial were televised. So it was a kind of sympathy for traditionalists who were worried that they would be, to use a phrase that comes from the gay rights movement, outed. And being outed is a very bad thing. The second of the cases was a case called Doe against Reed, which involved the state of Washington. Washington had passed something that was called kind of colloquially the Everything But Marriage Act, because it allowed registered domestic couples, civil unions in Washington state, to have all the same rights minus like one or two that married couples get under Washington law. And Washington state, like most Western states, has a referendum process. And so if enough voters want to, they can put on the ballot the question, should this law that the legislature just passed be repealed? And so a group called ProtectMarriageWashington.com went out and got several 100,000 signatures of people who said, we want to repeal the Everything But Marriage Act. But Washington state also has a very expansive Public Records Act, a kind of Government in the Sunshine Act, that says basically any person in Washington can get virtually any document in the government's possession just by asking for it. And so people who were supporters of marriage equality and of gay couples requested the names of all the people who had signed the petition to get rid of the Everything But Marriage Act, in the hope that they could talk to these people and persuade them to change their views before the actual election. And the supporters, the ProtectMarriage.com people, filed a lawsuit saying that it violated their First Amendment privacy rights for the government to reveal their names because they ran the risk of being harassed by people who would have what they referred to as uncomfortable conversations with them. And interestingly enough, here, the Supreme Court ruled the other way and said that Washington's Public Records Act was not facially invalid, and that these people would have to go back and show there was a real serious risk to them, because otherwise Washington state's interest in having an open election system and open information would be enough. And finally, and this is the case that I'll turn back to in a moment, the Supreme Court decided a case by a very bitterly divided 5-4 vote called Christian Legal Society against Martinez. And this was a case about the University of California Hastings Law School, which is a public institution in California. And they give money to student groups. If you're a registered, recognized student group, you can get money from the school to send students on trips to national conferences and to have pizza, because it turns out that the main determinant of whether law students will go to a panel discussion on anything is the food. We have a saying at Stanford about students who manage to make it through their entire first year of law school never actually buying lunch, because they go to everything. And by the end of the year, they get so picky that the organizations sometimes have to put on their sign what food they're serving in the hopes that the students will still come. So you'll see sometimes it'll say like national security, discussion of the Al-Aqwi case, which is a case about whether the United States can engage in targeted assassinations of American citizens overseas who are believed to be terrorists. Lunch, not pizza. You know, and some of the students are there because they're interested in targeted assassinations, and some of the students are there because they don't want to go to the panel that's more interesting because that panel has pizza. So you need money from the school to buy the pizza. And Hastings had a policy, as almost every law school in the country does, that you could not discriminate. The school does not discriminate on the basis of a laundry list of characteristics. And the laundry list at Hastings, fairly typically, like most law schools, includes race, includes sex, it includes national origin, disability status, veteran status, but also on their list, as at most law schools, sexual orientation. And the Christian Legal Society, which was a small group affiliated with a national organization, took the position that one of their fundamental beliefs is that sexual intimacy is permissible and students will engage in it only within a marriage between a man and a woman. So their policy was they disapproved of all non-marital sex, and by the way, marital sex between same-sex married couples. And therefore, you couldn't be what they called an unrepentant homosexual and join their group. And so Hastings said, well, you can have a group like this. We can't interfere with your right to have meetings and have a group like this, but we are not giving you student funds because you're violating our non-discrimination policy, which requires you to be open to any student without regard to sexual orientation, among other things. And they brought a lawsuit saying it violated their First Amendment right to freedom of association, and also it violated their right to free exercise of their religion and so forth and so on, to deny them money because of their religious beliefs, and to treat them differently than other student groups that were allowed to have beliefs as part of their organizing mission. So, for example, Hastings has both a pro-life student group and a pro-choice student group. It has a number of other religious groups, but none of them denied students the right to join based on sexual orientation. And the Supreme Court ruled 5-4 in favor of Hastings and said Hastings has the right to have this all-comers non-discrimination policy. So you can kind of see these cases are all about marriage in one way, but they're all about a lot of other issues in constitutional law in another way. They're about, should you televise trials? What should government funding look like? How should elections be run? Which are not issues just about gay marriage. And so the question is, like, how much is the backdrop of these cases going to affect how the court thinks about these issues? Because one of the things we know as a historical matter is that during the Warren Court era, the era between 1954 and 1969, which is the era in which the Supreme Court was at its most expansive with regard to issues of racial justice, the Supreme Court decided a series of cases that had race inflecting them, or to use Bert Newborn's phrase about this, in which race was exercising a gravitational pull. So that the Supreme Court decided free speech cases about libel by thinking about the civil rights movement's criticisms of Southern officials. It decided cases about the meaning of state action, which has meaning for all sorts of issues because of racial justice issues. It decided a lot of criminal justice cases, really because it was thinking about race and not because it was thinking primarily about crime. And I think the same thing's going to happen with sexual orientation. It's going to inflect the Supreme Court's decisions in a wide variety of areas. Now, one last thing before I say something about the case, and I should say you should interrupt me during the talk as well as at the end. I know philosophers tend to read their papers, because I go to philosophy workshops, and every word is like very important and was chosen to be that word. Law professors, not so much. I mean, like when we're litigating cases, we'll spend huge amounts of time discussing what does the word any mean. More time than any philosopher's ever spent on does any mean every or does any mean some. But when we actually talk about the law, we tend to be much more loosey-goosey. So you're not going to be destroying my train of thought or anything like that. Or if there's something that's unclear, really do feel free to just chime in. So the justices are confronting this rapid cultural change with regard to sexual orientation. And at the same time, there's another set of rapid cultural change that the justices are confronting. And that's with respect to methods of expression and association, and understandings of privacy and technology more generally. Last year, the same day that the Christian Legal Society case was being argued, Supreme Court heard two arguments that morning. So one of them was about the Christian Legal Society, and the other was a case called San Diego against Kwan, which probably nobody in the room really paid much attention to. But it was a case about whether a police officer on a SWAT team in San Diego, who was using his government-provided pager to send messages to his wife, but also to his 3 girlfriends. This was part of the problem. Had an expectation of privacy in those messages, such that when the government read the messages, not to mention that his wife read the messages and so forth and so on, his Fourth Amendment right to be free of unreasonable government searches had been violated. And the thing that was most striking about this argument is not that the Supreme Court decided in favor of the government, because that was almost a foregone conclusion, but that the justices spent a huge part of the argument trying to understand what a pager does. So there were questions like the following. If you try to send somebody a text message and they're trying to send a text message at the same time, do you get like a message saying, "I'm sorry, I'm busy right now, your message is very important to me"? Another great question that one of the justices asked was, if you erase a message, does it disappear? You know, it's right up there with the famous George Herbert Walker Bush thing when he went to the grocery store and there was that scanner and he says, "How does it know it's milk?" Which, for those of you in the audience who are philosophers, might raise this kind of deep ontological question, you know. And the first time I read it, that's what I thought, because, of course, it's, when you say, "How does it know it's milk?" the "it" isn't specified very well. And I thought it was like, how does milk know itself to be milk? And it turns out, no, he meant, how did the scanner know this? And, you know, that's a stupid question. Now, how does milk know it's milk is a deep question. How does the scanner know is a mechanical question of, it's been programmed. So the justices are asking, like, if you erase something, does it disappear? And there was a famous example of this that a friend of mine told me about when I was making fun of this. A friend of mine who had clerked at the Supreme Court the year that Chief Justice Rehnquist discovered that the justices' home addresses were on the web. You could Google the justices and get their home address, and then asked whether the Supreme Court should take its computers offline. Which is sort of right up there with like an ostrich, right? If we don't know that our numbers, if we can't Google our numbers, then no one else can. So, you know, this is a group of people who are somewhat behind the understanding of what the internet is about. The year I was there, just to give one last example of this, I don't know how many of you have ever used LexisNexis. It's a legal database. And Justice Marshall thought at one point, after they had a little talk from the people at LexisNexis, that he could probably dispense with having law clerks because he could just ask the machine the question and it would give him the answer. And one of the things you learn in law school is even if you know what you're doing and you ask the machine, it won't give you an answer. But the idea you could simply ask it a question like, what have we said about the following things in the past? I urge you, if you ever want to just have a fun time, just use natural language search on Lexis 2 or 3 times and ask it a question about which you'd like to know the answer, and it will come up with something insane. I mean, it's almost like a parlor game. So the justices, you know, they're trying to deal with rapid social change. They're trying to deal with rapid technological change in which people's understanding of what counts as privacy and people's ability to aggregate and disseminate information is different than it ever was in the past. And they have to think about this really hard. And what this means is that a lot of the gay rights cases that are going to be up at the Supreme Court are going to involve this interaction of technology and social change. And what's going to happen is that they're going to involve the claims of gay rights opponents more than they're going to involve the rights of supporters. I think a lot of the agitation at the Supreme Court last year, and the tone of these opinions was really quite striking in how bitter and angry a number of the opinions were, comes from the fact that some of the justices, particularly those justices who are more culturally conservative, have the sense that they're fighting a rearguard action to prevent traditionalists against an emerging mainstream. And their sentiment that the political process is treating traditionalists unfairly just reverberated throughout the term. It just really was striking. So that by the end of the term, when you get to Christian Legal Society, you have an opinion by Justice Alito where he says that prevailing standards of political correctness threaten cultural conservatives with marginalization. And I remember last year at a seminar I was at in the summer, I need to give you a little bit of background so that you'll get the punchline of this. But the little bit of background is this. The Equal Protection Clause of the Constitution says that the government can't deny people the equal protection of the laws. And generally, when courts are faced with, you know, and every law classifies people. I'm just going to get up and do a little thing on the board. For those of you at home, just imagine what I'm about to do. So, you know, any line classifies people. So when, for example, the state of Montana says you can't get married until you're, what, 18 probably, without your parents' permission? I don't want to find out this is like Arkansas where you can be 7.5. You know, and you can marry your cousins. But it's probably like 16 or 18 that you have to be before you can get married without your parents' consent. Well, that's a statute that classifies people on the basis of age. When the university decides who to let into the law school and they look at people's LSAT scores and their undergraduate GPAs, they're classifying people based on prior academic achievement or perhaps future academic potential. But they're drawing a line and they're separating people into sheep and goats, right? So huge amount of government decision-making does that kind of classification. And generally, when the government classifies, courts, if they face a challenge, use something called rationality review. And what rationality review asks is the following question. Is the government's use of this line, bless you, is the government's use of this line rationally related to some legitimate government purpose? So it asks, is the government purpose legitimate? That's the ends question. And then the means question is there some rational connection? That is, can we come up with a story in which we can explain why the government would use this line? So for example, in my marriage, we're limiting marriage to people over the age of 18. What's the legitimate government purpose there? Well, it's to make sure people don't make a mistake and get married too young. And is age a pretty good way of saying that we want to make sure people enter into marriage with some understanding of the consequences and some sense of who they are and who the other person is? Yeah, sure, there are 12-year-olds who are qualified to marry. Romeo and Juliet, right? If they hadn't gotten married when they were 12, they wouldn't have gotten married at all. Star-crossed lovers, terrible things, right? But in general, it's good enough for government work to say age is good there. Or if you think about driver's licenses, are there some 12-year-olds who'd be good drivers? They have good hand-eye coordination, they're cautious, they have good judgment? Yeah. Are there some 30-year-olds who shouldn't be allowed to drive? Sure. But 18 or 16 or 15 seems like a decent line there. Is it true that some people who completely screwed off as undergraduates and test really badly on the LSATs will make superb lawyers? Absolutely. Is it true that there are some people who had straight A averages in college, aced the LSAT, and can't think their way out of a paper bag and have no judgment and have bad character? We've seen it done. But not a bad first approximation. And so when I teach my students about rationality review, I say the kind of fit here is sort of like hip hop. Right? The pants, they have to be recognizably pants, but they can be very baggy. They don't have to be form-fitting in any way. As long as it's recognizably pants, that fit is close enough. Okay. But there are some classifications that the government, if the government uses them, courts don't use rationality review. They use something quite a bit more searching. And this is referred to as heightened scrutiny. And under heightened scrutiny, the ends have to be more weighty. And in a moment, I'll give you the biggest example of this. And the fit between the means and the ends has to be much closer. And the paradigm of a heightened scrutiny classification, of a so-called suspect class, is race. When the government uses race, says black people over here, white people over here, or Latinos over here, Anglos over here, or the like, it can only do that if it has a compelling interest. Not just legitimate, but compelling. Saving money is legitimate, administrative convenience is legitimate, national security is compelling. And the fit has to be much closer. It has to be necessary to use race to meet that compelling government purpose. So for example, one of the arguments that you see about racial profiling for terrorists and the like is the end, preventing terrorism, compelling? Absolutely. But aren't there better ways of trying to figure out who's a terrorist or not than using people's race, or for that matter, their religion or the like? So these are the two kinds of tiers of scrutiny. This one, heightened scrutiny, the two big categories over here are race and sex. I once went to a demographers convention, by the way, and we got these great T-shirts, and the T-shirts said on the front, International, Conference on blah, 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 demography, and on the back it just said broken down by age and sex, which I thought was a great caption for a T-shirt. But these get this, and over here are things like age, income, talent, any of these things, these just get rationality. Well, one of the big questions, and this is part of what Attorney General Holder's letter from yesterday did, is it said sexual orientation should be over here. It should get heightened scrutiny. It should actually get heightened scrutiny of the same kind that sex gets, which is a little less heightened than the kind that race gets. No federal court of appeals has yet held that heightened scrutiny should apply to sexual orientation. They've all used rationality review. And up until yesterday, the government was defending the so-called Defense of Marriage Act, which is the federal statute that says the federal government will only recognize marriages between one man and one woman. They were defending it as satisfying rationality review. And the rationale that the federal government was giving was, look, this is the way we've always done it, and things are changing fast, and we need to kind of wait and see. That's good enough for rationality review. That would not be good enough if you applied heightened scrutiny. And what Attorney General Holder said is, we've now determined that this is the appropriate standard, and therefore we can't defend the Defense of Marriage Act anymore because we don't think that it satisfies heightened scrutiny. Now, that's the backdrop to what I'm about to say about the Supreme Court, which is, if you looked at last year at the Supreme Court, it seemed as if the justices were prepared to offer heightened scrutiny to traditionalists about marriage before they get around to offering heightened scrutiny to LGBT people. That is, they think that the group that's most under attack in America today, in some ways, is people who oppose same-sex marriage, not people who want to enter into same-sex marriages. And that's, I think, a really interesting difference between where the Supreme Court is in its thinking right now and where the political branches seem to be going, which is a much more free-flowing and complex back and forth. That is, I don't think that, to quote George Bush II, who once said, "I believe we're on an inevitable course towards more freedom and democracy, but that could change." That's actually my favorite George W. Bush quote. The vector of public support is, if you look at it in the sort of long term, is absolutely clear because the demography is what it is. That is, among people under the age of 25, the support for marriage equality spans every different group. That is, white Protestant evangelicals under 25 are evenly divided on whether to recognize same-sex marriage, whereas virtually no group of Americans other than perhaps gays over the age of 65 is in favor of marriage equality. And so people are just, in some sense, waiting for the old generation to pass away to end up with marriage equality. But that's going to take a long time. And in the meantime, you're going to have this real perturbation in which things go in both directions. So maybe I should stop here and see if people have questions before I talk a little bit about Christian legal. I don't know if you all have questions at this point. No? Yes?
So you had mentioned that the technology and the revolution in technology and understanding privacy was in some sense contributing to the feeling that the cultural conservatives are the group that's actually under attack in this situation. I was wondering if you could maybe elaborate on that connection.
Sure. So the examples that the Supreme Court pointed to are, and there was a version of this that I confess even I, voyeur that I am, became interested in, which was in California. If you give more than $100 to any ballot measure, if you contribute money to any ballot measure more than $100, your name and address are a public record. Now, in the old days, if somebody wanted to know whether you gave this up, they would have to traipse up to Sacramento and sit in a room and go through a whole bunch of paper. Now, there are aggregators who put this stuff all up on the web. So I could look and see which people at Stanford University gave money to the Yes on 8 campaign, right? And one of my colleagues gave a substantial amount of money to the Yes on 8 campaign. And I know that now about him in a way that it wouldn't have been worth my spending hours to find that out. But if I can sit in my office and press 2 buttons and find that out, will I find that? Yeah. And was I as friendly to him afterwards? No. No, I was not as friendly. I mean, I didn't go up to him and start screaming at him. In part because I understood why he did it, which is he's a bishop in the local Mormon church, and they were directed essentially to give the money. And I respect him. I respect his right to his religious beliefs. On the other hand, I wanted to go up to him and say, why don't we take your marriage away too? Why don't we just get rid of everybody's marriage? How about that, Rob? Right? I could have said that to him, but I thought it would be nicer to be polite. But some people weren't polite. So there were people who gave money, whose restaurant, they run a restaurant or they run a mom and pop store, and people stand outside and picket their store now, saying, I don't want to buy from bigots and you shouldn't either. Some of them got emails, right? Because one of the things is the ability to aggregate the information and then piece it out again is such to make it much easier for people to engage in a kind of harassment that you couldn't have done in the past, because you would have had to drive to somebody's house to scream at them. Or you'd at least have to pay 31 cents and figure out what their mailing address was. So that's all gone away, and I think that's part of what's contributing to their sense that, because the cultural conservatives filed all these briefs with the Supreme Court saying we're under siege. Like if you let people know who we are, terrible things will happen to us.
Okay, so it's the idea that there's a group of people that are not only sort of out of sync with the trajectory of culture, but also out of sync with the trajectory of technology.
Well, no, it's the technology allows for allows new possibilities and forms of harassment against people who are cultural dissenters. And those forms didn't exist in the past. Right? I mean, it's like I don't know. These are the kinds of things you don't even want to admit you do in public, but people go on Zillow all the time to find out how much their friends' houses are worth. Do you do this? I shouldn't ask you this, right?
I have friends that have houses.
Okay, well, you're
I'm a grad student.
Oh, well, soon. Or go and look, like, if you know where go look at, like, the houses of your people who are friends of your parents or something, right? Tell your parents about this. They can look at their friends' houses and find out. So you go online and you find out, like, what do people think these houses are worth? It's amazing what you can find out. I gave a talk at Alumni Weekend at my old law school, in which I was talking about political campaign contributions. I said, I can figure out what all of you are doing. And I said, let's have a volunteer from the audience. And I pulled some guy up from the audience and went to one of the websites, opensecrets.org or openpolitics.org, and it lists all of the money he's given to federal campaigns in the last 10 years. And the minute I did this, first of all, everybody in the audience was, and then the next thing is they're all like whipping up their things to write down the website so they can go and do it themselves. So it's the technology just. Do you teach any undergraduate sections?
I have, yeah.
Have you tried talking to undergraduates about privacy recently?
Last year I did a little bit.
Were you shocked?
Not really.
Oh, maybe you're younger
I'm
than you.
probably closer to them.
Yeah, because I mean, mine. It's like the things they put on their Facebook websites, which they don't understand are there forever, no matter what Facebook tells them.
Yeah.
Somebody's got that stuff, and the stuff they'll allow, the cookies that aggregate all of the information about them, so that they get targeted ads. I have an undergraduate right now in the ethics program who's writing his senior honors paper on how should you, as a ethical citizen, respond to the fact that now the political ads that you get are tailored to go after your particular prejudices, as opposed to being ads that make arguments to people more generally. That is, everything's narrowcasted now, right? And that's because we know more about you. I mean, companies know more about you than they could have known 10 years ago. So our notions of privacy are in some tension with constitutional thought about what privacy means. So that's what I mean by the two being connected. There's a hand up. Yeah.
Well, sort of a question, sort of a tribute to you as a teacher, because I shouldn't be talking right now because I'm reading about this, but you energized me with the way you presented this. And to follow through, first I had this private versus state dichotomy, and then the thing that you said that caught my attention, and I sat here and it did come around again, was the risk of cultural conservatives being threatened with marginalization. And that stuck in my mind as you talked about this. And the thing that's really arresting my attention, I think, is what a leap that is from government oppression, or the bulwark against oppression by the government of the Constitution, to a sort of plea for government that goes something like, help us out here, things are passing us by.
Well, yeah, I mean, it's a little more complex in a way, because, of course, they are talking about the government facilitating the oppression. So it's the government got our names and addresses as part of the process in Doe against Reed of putting the stuff on the ballot. Or in Christian Legal Society, right? I think it's no accident in a weird way that the Christian Legal Society case that went to the Supreme Court is a case from a law school in San Francisco. Because a huge number of law schools caved in to the Christian Legal Society when they were threatened with lawsuits. Hastings, being in San Francisco, it was politically unpalatable for them to cave in. That is, when CLS said we want to be able to exclude gay students, Hastings just, Hastings has many more gay students probably than students who might join CLS. I think CLS at Hastings had 8 students in it. And the LBGT Student Association, the Outlaw, or whatever their version is called, must have like 200. So there, right, the case is teed up really nicely for the conservatives to say, we're the oppressed minority in a place in which the political system has gone over completely to the other side, which the combination of Hastings and the fact that the California Attorney General will not defend the state's constitutionalization of traditional marriage means that if there's any place where cultural conservatives have the claim that the government is just not, and they won in the political process, and now the Attorney General says, not going to defend. Not only am I not going to defend, I'm not even going to appeal so that somebody else can defend, right? Which is a little different than Eric Holder's position. For those of you who are sort of wondering about what did Eric Holder do yesterday, he said, the Department of Justice cannot defend this statute, but we will stay in the case at all points so that the courts can decide it. Whereas when Jerry Brown and Arnold Schwarzenegger said, we're not going to appeal the ruling against California in the marriage case, it raised the very real question, which is now in a very complicated form of back and forth litigation between the state and federal courts over whether anyone can defend California's traditional marriage provision. Yeah.
You pointed out the inevitability of the recognition of same-sex marriage, and it sounds more complicated than it is, but when the King of Saudi Arabia rents the Hay Adams Hotel in Washington, D.C., he brings more than 50 wives.
It doesn't surprise me in the slightest.
And so I'm assuming that if he ended up in the hospital in Washington, D.C., under comedy anyway, each one of those wives would be able to visit him without any question. So my question here is there the same inevitability about being able to be married to more than one person at one time of either or different sexes? Or is the real answer marriage was invented before people lived this long?
Well, marriage was invented before people lived this long. Till death do us part was basically like saying until next Wednesday at one point, right? I mean, it wasn't what it is now. So you're raising a very complicated question, and I want to be sure I answer it in the right way. As a matter of federal law, if the King of Saudi Arabia gets booted out because they have a bunch of demonstrations or something, and he gets booted out the way Mubarak does, and he decides he wants to come and live in the United States, he's only going to be entitled to one wife. He can bring all those other women with him, and they can all live in a house together, but only one of them will be recognized as his legal wife for purposes of American law.
You mean like IRS?
Yeah, like the IRS, and if there's medical decision making and he's incompetent and the decision is to be made by a wife, it's like first in line. Whichever wife was the first wife, that's a valid marriage. As a matter of American law, every marriage after that's invalid. So in the short term, the answer is you get one wife, at most. In the longer term, here's the answer. If in the United States there came to be a social movement for polygamy that gained enough political traction, at some point, that would lead us to think about changing our marriage laws. That is, the question here, and I'm going to talk about this a little more tonight, not so much about same-sex marriage, but in other contexts, is the understanding of constitutional rights changes in response to changes in society in various ways. So that we understand today that black people are people, In 1857, the Supreme Court basically said the black man has no rights that the white person is bound to respect. Well, that's changed. Now, what changed that? The Civil War, among other things, changed that. We now understand that mentally retarded people are people entitled to constitutional rights in a way that, in the 1920s, we didn't understand when we had a kind of eugenics view that led to massive forced sterilization of people with only mild mental impairments, and often without any real determination of whether they had the mental impairment or not. Like the parent would just come in and say, my child seems a little slow, sterilize them. And today we don't do that because we understand that people with mental disabilities have rights as well. So I find it hard to imagine an America in which at some point there will be a large category of people who support polygamy again. I should put the again in there because, of course, there was times in the past when they did. But if we were to do that, then marriage will change to accommodate that. In the same way, of course, that marriage changed to get rid of that. That is, the same people who say, I want traditional marriage, ought to go and read the Old Testaments if they want to talk about traditional marriage, because those marriages, a lot of those people had multiple marriages in the Old Testament. So the answer is, I don't know 400 years from now, or maybe even 100 years from now, whether we'll be having serious arguments about polygamy. I don't think we'll be having those arguments anytime in the near foreseeable future because there isn't a social movement that has real traction behind it. Other? No, yeah.
I kind of have a quick question. You mentioned like the cultural conservatives, and you characterize their viewpoints as basically society's dissenters. And I don't know, maybe I'm just not as optimistic as you are, but
I don't think of them as society's dissenters. They're claiming to be society's dissenters.
okay, but you are confident there's a growing movement, because I'm just a little, I guess, disheartened by the fact that most of LGBT victories have come through the judicial branch rather than the legislative branch. So I just guess I'm getting more an optimistic vibe from you than what reality is telling me.
I'm not sure that that's true. That is, by the time the Supreme Court struck down the Texas sodomy statute, almost all of the other states that had criminalized sodomy in 1987 had gotten rid of it as a matter of legislative. They had rewritten their criminal codes and had taken homosexual sodomy out of the codes. So by the time the Supreme Court got to it, there were only like 4 states that criminalized only homosexual sodomy, and there were only 9 states that criminalized adult private sodomy at all. Whereas if you go back to 15 years earlier, there were like 25 states. Most of the non-discrimination provisions that deal with things like employment and housing and the like have not been through courts at all. They've been through the political process. Now that has its fits and starts and its back and forth. But one of the interesting things is the way in which the legal cases change the kind of frame in which the political discussions occur. So if you went back to 1987, nobody was arguing in favor of same-sex marriage. And now what you have is a large number of people arguing in favor of it, but an even larger number who are not quite comfortable with the idea of marriage equality, but say, well, we have to have some recognition for same-sex couples. So for example, in California, the General Assembly did something called, I think it's Assembly Bill 497, I can't remember the exact number now, but it gives same-sex couples who are registered domestic partners in California all of the same rights under California law that married couples would have, save for 2 that involve the state pension system, which they couldn't do because it would have caused them problems with respect to federal law, given DOMA. I think within the next 10 years, ENDA, which is the Employment Non-Discrimination Act, is going to be passed by Congress, which will treat discrimination by large employers on the basis of sexual orientation the same way that discrimination against the disabled, racial discrimination or sex discrimination is treated. So I think that's going to happen too. There are some things that courts have to do, but the courts clearly don't do this on their own, and the courts don't ever act all that far out ahead of where elite public sentiment is in some ways. And they're never all that far behind where it is, which is why I think, for example, Ted Olson who was George Bush's Solicitor General, brought the California marriage cases. He's confident, and you and I might be a little more worried about this than he is, but he's confident that sort of where country club Republicans are now on this is, marriage equality makes sense. And Anthony Kennedy, who's the swing vote, is a kind of California libertarian country club Republican, so he's going to be comfortable with this. Now, Ted might be right about that, or he might be wrong about that. But 15 years from now, he's certainly going to be right about where those folks are. So I'm sort of optimistic in the longer range. And the repeal of Don't Ask, Don't Tell. Like, where did that come from? Right? And there was this huge opposition, and on the floor, the Republicans were going to block it, and then all of a sudden, it just goes through. And so I'm not nearly as pessimistic. I think, I'm not sure I would have brought a marriage case to the U.S. Supreme Court right now. But I'm not pessimistic about, in the long run, is there going to be lots of legislative change? Because it turns out, and this goes back to the story I was telling at the beginning about the Supreme Court itself, it turns out that the major determinant of people's attitudes towards equal rights for LGBT people is whether they know that they know any. And so the coming out movement of the 1980s and 1990s has had this huge effect. That is, very few people who know that they have relatives who are gay say, well, those people should never have the right to protection on their job, and they shouldn't have, And the other thing is, of course, as the coming out became a more widespread thing, many more people who are extremely conventional with respect to everything other than their sexual orientation became known to be gay. And that makes a big difference, right? Because if your only image of gay people is gay men in the Castro, your notion about gay people is going to be very different than if your next door neighbor is lesbian and your niece is a lesbian and the teacher that you had in high school that you admired very much turns out to be gay, right? That's going to change your view of things as more conventional people, that they're just like us except for this one thing, as opposed to they're very, very different people. So I think all of that has a major effect on how the court thinks about things. I remember Justice Blackmun coming back from the oral argument in Bowers, and he used to read us his notes of what all the other justices would say in conference. Because the justices go into a room and discuss the cases, just the 9 of them in there. But Justice Blackmun, who was he had been a tax lawyer before he became a justice, and so he was very compulsive. He took these incredibly detailed notes, which he left to the nation. They're all in the Library of Congress, and you can go read about any case that he sat on during the 23 years he was on the Supreme Court. But he came back and he read us his notes, and he gets to Justice Powell saying, I don't think I've ever met a homosexual. And the justice paused, and he looked up, and he said, I felt like saying to him, Lewis, look around your chambers, man. Because Justice Powell actually had a gay clerk that term who had introduced him to his boyfriend. But he said, this is my friend. And the justice thought, oh, isn't that nice? And the year before, he had had a lesbian clerk whose partner had moved to Washington with her for the year, and she brought her partner to the Christmas party. And the justice said to somebody, isn't it lovely she has a friend who has come to spend the year with her? The guy just, he's a little clueless. He also once asked somebody whether they were eating a piece of pizza. He really had been sheltered in his life. Is that pizza you're eating? So they're not always the most with it people. You don't get to be on the Supreme Court by being with it. But once all this stuff changes, it changes the way the justices think about equality. I think having 3 women on the Supreme Court changes how they think about things. There was a case 2 years ago, another privacy case. It was a case called Safford School District against Reading. And it was about a little girl who was strip searched, a junior high school girl who was strip searched because they thought she had some extra strength ibuprofen on her. And while the case was pending, at the oral argument, it looked like they were going to rule for the school board. But while the case was pending, Justice Ginsburg gave an interview to Joan Biskupic, who's the USA Today Supreme Court correspondent, in which she said, these guys, they do not understand what it's like to be a 13-year-old girl. Because none of the justices are transgender. right? So the male justices could not possibly have understood what it was like to be a 13-year-old girl. And then the court came out, surprise, surprise, ruling in favor of Savannah Redding. And I think some of it is having Justice Ginsburg in the room saying, you don't understand, like, when you're 13 years old, you are so sensitive about everything. The idea that, like, officials in your school are going to make you pull off your bra and pull your underpants out so they can look in your underpants, you know, and Justice Breyer, who's generally very pro-civil liberties, at the oral argument saying things like, I don't get what this is all about. I mean, people used to poke things in my underwear in gym class all the time. Right? It's such a guy thing, right? You know? But seriously, I mean, the serious point behind this is social meaning affects how judges interpret the open-ended pieces of the Constitution, like the Equal Protection Clause. Yeah, you had your hand up.
What year was that, the Advil case?
The Advil case was last year, so 2010. 2010. Yeah.
I'm just, since you clerked on the court, I'm so curious as to the law clerk's reactions or discussions about Bowers versus Hardwick.
Yeah.
I mean, I can imagine there had to be some rather remarkable debates.
Well, you know, there weren't a lot of debates. There were some very, very conservative law clerks my year, and some very liberal ones, obviously. You know, the original vote in Bowers, I mean, this is all public. I'm not telling you anything that you couldn't find out if you just went and looked at the papers, but the original vote in Bowers against Hardwick was 5-4 to strike the statute down. Justice Powell was leaned on very heavily by 3 of his clerks to vote in favor of striking the statute down. The gay male clerk, a female clerk, and interestingly, the leading, I think it's fair to say, the leading evangelical Protestant law professor in the country in some ways, a guy named Bill Stuntz, who's a professor of criminal procedure at Harvard, who has written a lot on Christianity and the law, and who's a very strong evangelical Protestant, also, who just didn't think this was right. And so they all worked very, very hard on Justice Powell, who felt a lot of discomfort about this and decided originally that he was going to vote to strike the statute down, not on the grounds that it violated fundamental liberty interests or even that it treated people unequally, but on the grounds that it would be cruel and unusual punishment to imprison a homosexual person for engaging in the kind of sex that homosexuals engage in. So it would violate the cruel and unusual punishment clause of the Eighth Amendment, which honestly is not a particularly great argument. But they had persuaded Justice Powell of this. And so Justice Blackmun was assigned to write the opinion for the court. And we were at breakfast on the Monday. I think the court decided the vote was on a Friday. It was either on a Wednesday or Friday. And the next Monday, we were downstairs at breakfast with the justice. And the justice was really kind of shaking his head and saying, I don't know how we're going to write this, because nobody else thought that was a good argument. But you need, the most important thing a Supreme Court justice can do, this is a line of Justice Brennan's, is count to 5, which means get 5 votes on your side in a case. That's the most important thing you can do, and everything else flows after that. So Justice Blackmun said, well, he turned to me and said, well, why don't you take a crack at a first draft? So I went upstairs with my co-clerk, and we were sitting upstairs, and the phone rang, and it was Justice Blackmun's secretary, who said, you need to come down here, and you need to come down here right now. Justice Powell has changed his mind. And he had, over the weekend, he'd been leaned on, and his official biographer says what happened is that he had his 4th clerk, who was very, very conservative, now a federal district judge, by the way, worked on him really hard to make him change his mind. And the Chief Justice called him up and, you know, worked on him very hard to get him to change his mind, and he changed his mind. And so there was a lot of, you know, back and forth among the clerks in the building. But the clerk, you know, the thing is, like, there are some cases where the clerks have a lot of influence on the justices. This was not really one of them, with the possible exception of Mike Mossman having this tremendous influence on Lewis Powell. Because when it comes to big constitutional issues, the justices know what they think, and they're not likely to be swayed by their clerks. When it comes to narrow statutory cases on statutes about which they don't give a hoot, then you can have a real influence. I mean, I worked on a case that involved a piece of the Earned Income Tax Credit and the Omnibus Budget Reconciliation Act, and I tell you, none of the justices had any intuition about this. Or my favorite case like this was a case I worked on that was about whether if you go to a casino that has slot machines, you know they have guaranteed payouts on the slot machines, you know, guaranteed this machine will pay out $3 million. And the question in the case I worked on was whether the casino could deduct the amount of the guaranteed payout only in the year in which somebody hit it, or in the year in which they were forced to put the money into escrow so they could pay out if somebody pulled it. You know, do the justices have a view on this? You know, does it talk about fundamental anything? No. So on something like that, you know, if the clerks say to them, well, I've read the legislative history and it's clear this is what Congress meant, they're likely to say, well, if that's what you say, go with it. But on something like this, obviously all the clerks talked about it all the time. It was one of the biggest cases of the term. But there was very little, you know, in the way of our talk having anything to do with what the justices did. Justice Blackmun's dissent, for example, is based largely on his discussions at the Aspen Institute. He used to teach at the Aspen Institute in the Justice and Society program, and he used to do a day on the Hart-Devlin debate, which is a debate between H.L.A. Hart and Lord Patrick Devlin on whether homosexuality could be criminalized. And he had thought about that for years and years and had taught it as part of a seminar. And much of the discussion in his dissent is based on that, because that's what his thoughts had been. It wasn't based on things that the clerks came up with and said, you ought to put this in. Whereas, you know, in the case about the tax thing with he did not, even though he had been a tax lawyer, he didn't have a whole lot of intuitions about that beforehand. So let me say a little bit about Christian legal. I know we're getting towards the end of our hour, and that is that what was so interesting to me about the Christian Legal Society case is that it forced the court to try and deal with simultaneously the question of whether homosexuality is best described as a status, that is, people are homosexuals, or an act of conduct, that is, people engage in homosexual activity, or a belief, that is, a system of beliefs about what sexual activity is acceptable or not. At the same time that they were trying to deal with whether that's true of religious groups. That is religion a status? That is, I am a Jew, I am a Muslim, I am a Christian? Or is it about belief? Or is it about conduct? That is, when the Christian Legal Society says we will not allow unrepentant homosexuals to join our organization, are they discriminating against people on the basis of their beliefs, on the basis of their status, or on the basis of their conduct? And when they engage in excluding people, is that an act of belief, or is that an act of conduct? And the Supreme Court, interestingly enough, I think kind of mushed the two together to say that gay people, that being gay is a status, which is a step, I think, on the road to saying it deserves protection, because generally conduct by itself doesn't get that sort of high-level constitutional protection unless it's fundamental conduct that's fundamental to human rights. And so the Supreme Court said, we have not distinguished between status and conduct when it comes to gay people. And then said, and by the way, we think we're not penalizing you, Christian Legal Society, for your beliefs at all. We're treating you less favorably because of your conduct, which is excluding people from the group. You can believe whatever you want. What you can't do, having believed that, is discriminate against people by denying them access to your group. And I think that what happened, and part of what drove the dissent, which was written by Justice Samuel Alito, and which has an almost Rumpelstiltskin-like rage to it over the way the court is going, is that they thought religious groups are uniquely worthy of protection, and that gay people are not a group entitled to special protection, and that the court was flipping the traditional way of protecting people upside down. Yeah?
And your comments sort of reinforce what I was thinking earlier, which is that in the social shift from the 50s and 60s into the 21st century, with gays and lesbians coming out, our perception of them also has to change in a couple of ways. If we turn the clock back, it's, our perception is the Castro gay person, and our perception is really more one of conduct than of status. But as we see more people coming out, our next door neighbors, now we know it's not conduct so much. And there's some, and I'm thinking sort of society's grokking of what's going on. And so now the perception is one of status rather than conduct. And it seems if we haven't made the argument strongly in the first CLS case, in the second one maybe we do, that status is the issue. And that it is the coming out that also moves sexual orientation out of rationality over into heightened scrutiny. Also because now we recognize that unlike race and sex, which we, for the most part, can't hide, in early days, we were able to hide sexual orientation, and many people did it very well. But now, as that changes, we also have to recognize that it was hidden for a reason. And it was hidden because of discrimination and persecution and everything else that went along with it, which now moves gays and lesbians and transgender and so on into that sort of minority status of having been past and significant victims of society's action.
Well, yeah, I mean, that's part of what Attorney General Holder says in his letter is that if you ask why are race and sex treated differently than other things, they're treated differently because, in part, they're thought to be inherent characteristics of people that have very little connection with their moral worth. Race and sex have been used as criteria for discriminating against people across a wide range of opportunities in a way that's invidious. And people shouldn't be asked to change their race or sex. That is, people shouldn't have been asked to pass in the kind of pre-civil rights era in which you have huge numbers of black people who can trying to pass. And
But I think it's the coming out that
right.
really has changed.
No, I think that's right. But the interesting thing is, of course, there's also large amounts of arguments over how much does it matter whether sexual orientation is immutable to people's claims for non-discrimination. And this is a way in which, oddly enough, sexual orientation and religion share some interesting parallels, which is for most people, their religion is immutable. They have a religion that they're born into and that they stay with. It's not true for everybody. And the entire notion of evangelical religions is you can take some people who weren't born you and turn them into you, right? And the interesting thing is today when you hear the word proselytizing, it's almost as often used by people who are making arguments about why, for example, gay people shouldn't be school teachers because they might proselytize, as it's used in its original meaning, which is as a religious term about going out and spreading the gospel of your religion. So you see two really interesting arguments that are on top of the point that you make that make this all very interesting and complicated as an academic matter, although not so much as a legal matter, which is, first of all, does the immutability have anything to do with people's arguments about protection? Because if immutability does, then maybe bisexuals shouldn't be entitled to any particular protection at all because they can choose, right? If you're willing to date men one woman and one day and women the next, then what are you being denied if we say no, just one group, right? Whereas for people who are at the kind of Kinsey ends of the spectrum, it's a different issue. And the second issue is marriage as an issue is one that has divided the gay community in really interesting ways because, a lot of people say there's something troubling about the fact that the two biggest and most popular movements for gay equality in the United States right now are let us get married and let us be in the military, which are two of the most traditional institutions in society. And to the extent that what you had before was a large part of the gay community that thought of themselves as an alternative community, there are a lot of people who say, actually, I'd rather have full civil union benefits than get married because I don't like the institution of marriage. And so for those people, something gets lost by being assimilated. There's a wonderful philosophical article some of you have probably read by Richard Wasserstrom called, I think it's called Racism, Sexism, and Some Approaches to the Problem. And it says there are three sort of end states that you might want. One is assimilation, in which everybody's the same along some particular dimension. A second one is tolerance, and a third one is diversity. And assimilation, in which gay people are just like straight people except for, the figures on top of the cake, is a different view than a view that says, well, there are many ways that people might want to organize their private lives. Marriage is one, but your ability to get health insurance and your ability to get survivor's benefits shouldn't depend on one rather than the other. So,
Thank you, Professor Crow.
Can I say one last thing, which is there's going to be a long version of this article coming out in the Supreme Court Review in another couple of months. And if you want a copy of it, you could just email me, carlin@stanford.edu, and I'm glad to send you the page proofs of it as a PDF so you'll have a copy of it. That was all I wanted to add. So, thanks.
Thank you.